Beckett Lawyers is a great place to get some professional advice on how to make a will. Gary Valentine's going to give us some very good tips. So Gary, if I don't have a will when I die, what's going to happen?
Dying without a will creates what they call an intestacy, and it's common that for a person to have a will to go through a process of probate. Intestacy is a system or a procedure where the Administration Act kicks in, and it actually deals with the distribution of an estate, and often it isn't what the actual will maker wanted in the first place. The Administration Act sets out a pecking order in terms of family members and relatives as to who gets what, when and how. So often it's good that the will maker thinks about who they want to actually distribute things to. Otherwise it's taken out of their control, and even worse, if there are no relatives actually left, the actual estate will go to the Crown, so it goes to government.
If I do have a will but it's getting quite old, do I need to update it?
It is important to update the will. We suggest say every 5 years, or particularly when circumstances change, and circumstances can be like entering into a marriage or a civil union or de facto partnership, and that's a good time to do that, because unless you actually put a provision in the will that contemplates a marriage or a civil union partnership, your previous will be automatically revoked.
Now, what happens with the money that's in my bank?
Okay, normally bank accounts are frozen unless the accounts are actually jointly held, which is commonplace for spouses in particular. What happens is survivorship kicks in, which basically means once the surviving spouse or partner can produce a death certificate, if a probate actually isn't warranted, or the probate document or letters of administration or some other grant, then the bank will just automatically close the account, and then those monies can then be realised and put into the estate. Otherwise, if it's just a joint person, they automatically go to the surviving bank account holder effectively.
Who can challenge a will?
Challenging wills, it's normally done in 3 ways. Firstly, under the Property Relationships Act, and that's where you've got a surviving spouse or a civil union partner or a de facto partner who can actually apply to have the will dealt with under the Relationship Properties Act. Another way is under the Family Protection Act, and that's where the courts have historically approached a view where the will maker should be making some sort of moral duty, obligation for family members. And a third one is probably not as used as commonly as it's called the Law Reform Testamentary Promises Act, and that's where you've got someone who has performed an act or some sort of service for the will maker, and that will maker's promised to make provision for them in their will.
For those of us that have a trust, do we need to have a will as well?
It is important still to have the will. A trust, there are a number of objectives and goals why to set up a trust. One of them being is that you want to make yourself effectively personally impoverished, in which case you're transferring assets during your lifetime into the trust, so that, for example, if death duties were ever reintroduced by a particular government, you wouldn't be taxed on your wealth. So that's one of the reasons why people do transfer their assets over into a trust while they're alive. But there are circumstances where you can't actually do that, and the will often deal with personal effects, where they may wish personal effects to go to particular people, or there actually could be property where they couldn't deal with the property at the date of death, and that could be a life interest for a partner in a house or a property, so that person can continue to live in the property until they actually die, and then on the death of that surviving person, the estate is then effectively transferred into the estate, into the trust, and then administered as per the set law or the will maker's wish, which is effectively one and the same person. I can be contacted at Holland Beckett, of course. My direct line is 571 3838, and I can also be contacted on email at Gary with a 1r.valentine@hobeck.co.nz.